The question is addressed to counsel for the President. As a matter of law, does it matter if there was a quid pro quo? Is it true that quid pro quos are often used in foreign policy?
Chief Justice, thank you very much for your question. Yesterday, I had the privilege of attending the rolling out of a peace plan by the President of the United States regarding the Israel-Palestine conflict. And I offered you a hypothetical the other day. What if a Democratic president were to be elected and Congress were to authorize much money to either Israel or the Palestinians, and the Democratic president were to say to Israel, no, I'm going to withhold this money unless you stop all settlement growth, or to the Palestinians, I will withhold the money Congress authorized to you unless you stop paying terrorists. And the president said, quid pro quo. If you don't do it, you don't get the money. If you do it, you get the money. There's no one in this chamber that would regard that as in any way unlawful. The only thing that would make a quid pro quo unlawful is if the quo were in some way illegal. Now, we talked about motive. There are three possible motives that a political figure can have. One, a motive in the public interest, and the Israel argument would be in the public interest. The second is in his own political interest, and the third, which hasn't been mentioned, would be in his own financial interest, his own pure financial interest, just putting money in the bank. I want to focus on the second one for just one moment. Every public official that I know believes that his election is in the public interest. And mostly you're right. Your election is in the public interest. And if a president does something which he believes will help him get elected in the public interest, that cannot be the kind of quid pro quo that results in impeachment. I quoted President Lincoln. When President Lincoln told General Sherman to let the troops go to Indiana so that they can vote for the Republican Party, let's assume the president was running at that point. And it was in his electoral interest to have these soldiers put at risk the lives of many, many other soldiers who would be left without their company. Would that be an unlawful quid pro quo? No, because the president, A, believed it was in the national interest, but B, he believed that his own election was essential to victory in the Civil War. Every president believes that. That's why it's so dangerous to try to psychoanalyze a president, to try to get into the intricacies of the human mind. Everybody has mixed motives. And for there to be a constitutional impeachment based on mixed motives would permit almost any president to be impeached. How many presidents have made foreign policy decisions after checking with their political advisors and their pollsters? If you're just acting in the national interest, what do you need pollsters? What do you need political advisors? Just do what's best for the country. But if you want to balance what's in the public interest with what's in your party's electoral interest and your own electoral interest, it's impossible to discern how much weight is given to one to the other. Now, we may argue that it's not in the national interest for a particular president to get reelected or for a particular senator or member of Congress. And maybe we're right. It's not in the national interest for everybody who's running to be elected. But for it to be impeachable, you would have to discern that he or she made a decision solely on the basis of, as the House managers put it, corrupt motives. And it cannot be a corrupt motive if you have a mixed motive that partially involves the national interest, partially involves electoral, and does not involve personal pecuniary interests. And the House managers do not allege that this decision, this quid pro quo, as they call it, and the question is based on the hypothesis there was a quid pro quo, I'm not acting the facts, they never allege that it was based on pure financial reasons. It would be a much harder case if a hypothetical president of the United States said to a hypothetical leader of a foreign country, unless you build a hotel with my name on it, and unless you give me $1 million kickback, I will withhold the funds. That's an easy case. That's purely corrupt and in the purely private interest. But a complex middle case is, I want to be elected. I think I'm a great president. I think I'm the greatest president there ever was, and if I'm not elected, the national interest will suffer greatly. That cannot be an impeachable offense. Thank you, Mr. Chief Justice.
Recognize. The question from Senator Manchin reads as follows. The framers took the words high crimes and misdemeanors straight out of English law, where it had been applied to impeachments for 400 years before our Constitution was written. The framers were well aware when they chose those words that Parliament had impeached officials for high crimes and misdemeanors that were not indictable as crimes. The House has repeatedly impeached and the Senate has convicted officers for high crimes and misdemeanors that were not indictable crimes. Even Mr. Dershowitz said in 1998 that an impeachable offense, quote, certainly doesn't have to be a crime, end quote. What has happened in the past 22 years to change the original intent of the framers and the historic meaning of the term high crimes and misdemeanors? It's counsel for the President's turn.
What happened since 1998 is that I studied more, did more research, read more documents, and like any academic, altered my views. That's what happens. That's what professors ought to do. And I keep reading more, and I keep writing more, and I keep refining my views. In 1998, the issue before this Senate was not whether a crime was required. It was whether the crime that Clinton was charged with was a high crime. When this impeachment began, the issue was whether a crime is required. Actually, 2 years earlier in a book, and then in an op-ed, I concluded, not on partisan grounds, on completely academic grounds, that you could not impeach for abuse of power and that a technical crime was not required, but criminal-like behavior was required. I stand by that view. The framers rejected maladministration. That was a prime criteria for impeachment under British law. Remember, too, the British never impeached prime ministers. They only impeached middle-level and low-level people. So the framers didn't want to adopt the British approach. They rejected it by rejecting maladministration. And what's a metaphor or what's a synonym for maladministration? Abuse of power. And when they rejected maladministration, they rejected abuse of power. Mr. Congressman Schiff asked a rhetorical question, can a president engage in abuse of power with impunity? In my tradition, we answer questions with questions, and so I would throw the question back. Can a president engage in maladministration with impunity? That's a question you might have asked James Madison had you been at the Constitutional Convention. And he would say, no, a president can't engage in that with impunity, but it's not an impeachable crime. Maladministration is not impeachable, and abuse of power is not impeachable. The issue is not whether a crime is required. The issue is whether abuse of power is a permissible constitutional criteria, and the answer from the history is clearly, unequivocally no. If that had ever been put to the framers, they would have rejected it with the same certainty they rejected maladministration.
Mr. Majority Leader.
Mr. Chief Justice, the next two questions, one from each side, will be the last before we break for dinner. I would ask that following the next two questions, the Senate stand in recess for 45 minutes.
Thank you. Senator from Alabama.
I send a question to the desk.
Thank you. Question is directed to counsel for the President. How does the non-criminal abuse of power standard advanced by the House managers differ from maladministration, an impeachment standard rejected by the framers? Where is the line between such an abuse of power and a policy disagreement?
Thank you very much for that question, because that question, I think, hits the key to the issue that's before you today. When the framers rejected maladministration, and recall that it was introduced by Mason and rejected by Madison on the ground that it would turn our new republic into a parliamentary democracy where a prime minister, in this case a president, can be removed at the pleasure of the legislature. Remember, too, that in Britain, impeachment was not used against the prime minister. All you needed was a vote of no confidence. It was used against lower-level people. And so maladministration was introduced by Mason, and Madison said, no, it would turn us, it was just too vague and too general. Now, what is maladministration? If you look it up in the dictionary and you look up synonyms, the synonyms include abuse, corruption, misrule, dishonesty, misuse of office, and misbehavior. Even Professor Nicholas Bowie, a Harvard professor who was in favor of impeachment, so this is an admission against interest by him. He's in favor of impeachment. He says abuse of power is the same as misconduct in office, and he says that his research leads him to conclude that a crime is required. By the way, the congressman was just completely wrong when he said, I'm the only scholar who supports this position. In the 19th century, which is much closer in time to when the framers wrote, Dean Dwight of the Columbia Law School wrote that the weight of authority, by which he meant the weight of scholarly authority and the weight of judicial authority, this is 1867, the weight of authority is in favor of requiring a crime. Justice Curtis came to the same conclusion. Others have come to a similar conclusion. You asked what happened between 1998 and the current to change my mind. What happened between the 19th century and the 20th century to change the mind of so many scholars? Let me tell you what happened. What happened is that the current president was impeached. If, in fact, President Obama or President Hillary Clinton had been impeached, the weight of current scholarship would be clearly in favor of my position, because these scholars do not pass the shoe on the other foot test. These scholars are influenced by their own bias, by their own politics, and their views should be taken with that in mind. They simply do not give objective assessments of the constitutional history. Professor Tribe suddenly had a revelation himself. At the time when Clinton was impeached, he said, oh, the law is clear. You cannot charge a president with a crime while he's the sitting president. Now we have a current president. Professor Tribe got woke. And with no apparent new research, he came to the conclusion, oh, but this president can be charged while sitting in office. That's not the kind of scholarship that should influence your decision. You can make your own decisions. Go back and read the debates, and you will see that I am right that the framers rejected vague, open-ended criteria, abuse of power, and what we had is the manager made a fundamental mistake again. She gave reasons why we have impeachment. Yes, we feared abuse of power. Yes, we feared criteria like maladministration. That was part of the reason. We feared incapacity. But none of those made it into the criteria because the framers had to strike a balance. Here are the reasons we need impeachment, yes. Now, here are the reasons we fear giving Congress too much power. So we strike a balance. How did they strike it? Treason, a serious crime. Bribery, a serious crime. Or other high crimes and misdemeanors akin to treason and bribery. That's what the framers intended. They didn't intend to give Congress a license to decide who to impeach and who not to impeach on partisan grounds. I read you the list of 40 American presidents who have been accused of abuse of power. Should every one of them be impeached? Should every one of them have been removed from office? It's too vague a term. Reject my argument about crime. Reject it if you choose to. Do not reject my argument that abuse of power would destroy the impeachment criteria of the Constitution and turn it, in the words of one of the senators of the Johnson trial, to make every president, every member of the Senate, every member of Congress be able to define itself from within their own bosom. We heard from the other side that every senator should decide whether you need proof beyond a reasonable doubt or proof by a preponderance. Now we hear that every senator should decide what abuse of power. Thank you, Mr. Chief Justice.
President. Mr. Chief Justice.
Senator. The question from Senator Rubio and the other senators is for counsel for the President. How would the framers view removing a president without an overwhelming consensus of the American people and on the basis of articles of impeachment supported by one political party and opposed by the other?
Thank you, Senators. Alexander Hamilton addressed that issue very directly. He said the greatest danger of impeachment is if it turns on the votes of one party being greater than the votes of another party in either house. So I think they would be appalled to see an impeachment going forward in violation of the Schumer rule and the rules of other congressmen that were good enough for us during the Clinton impeachment but seem to have changed dramatically in the current situation. The criteria that have been set out are so lawless, they basically paraphrase Congresswoman Maxine Waters, who said, there is no law. Anything the House wants to do to impeach is impeachable. That's what's happened today. That places the House of Representatives above the law. We've heard much about no one's above the law. The House of Representatives is not above the law. They may not use the Maxine Waters. Gerald Ford made the same point, but it was about the impeachment of a judge. Judges are different. There are many of them. There's only one president. But to use that criteria, that it's whatever the House says it is, whatever the Senate says it is, turns those bodies into lawless bodies in violation of the intent of the framers. Manager Schiff confused my argument when he talked about intent and motive. You've said I'm not a constitutional lawyer, but you admitted I'm a criminal lawyer, and I've taught criminal law for 50 years at Harvard. And there is an enormous distinction between intent and motive. Somebody shoots somebody, the intent is that when you pull the trigger, you know a bullet will leave and will hit somebody and may kill them. That is the intent to kill. Motive can be revenge, it could be money. It almost never is taken into consideration except in extreme cases. There are cases where motive counts. But let's consider a hypothetical growing out of the situation that we've discussed. Let's assume that President Obama had been told by his advisors that it really is important to send lethal weapons to the Ukraine. But then he gets a call from his pollster and his political advisor who says, we know it's in the national interest to send lethal weapons to the Ukraine, but we're telling you that the left wing of your party is really going to give you a hard time if you start selling lethal weapons and getting into a lethal war, potentially with Russia. Would anybody here suggest that was impeachable? Or let's assume President Obama said, I promised to bomb Syria if they had chemical weapons, but I'm now told by my pollsters that bombing Syria would hurt my electoral chances. Certainly not impeachable at all. So let me apply that to the current situation. As you know, I said previously, there are three levels of possible motive. One is the motive is pure. Only interest is in the way what's good for the country. In the real world, that rarely happens. The other one is the motive is completely corrupt. I want money, kickback. But then there's the third one that's so complicated and that's often misunderstood. When you have a mixed motive, a motive in which you think you're doing good for the country, but you're also doing good for yourself. You're doing good for me, you're doing good for thee, you're doing good, and you altogether put it in a bundle in which you're satisfied that you're doing absolutely the right thing. Let me give you a perfect example of that from the case. The argument has been made that the President of the United States only became interested in corruption when he learned that Joe Biden was running for a president. Let's assume, hypothetically, that the president was in his second term. And he said to himself, you know, Joe Biden's running for president. I really should now get concerned about whether his son is corrupt, because he's not only a candidate, and he's not running against me, I'm finished with my term, but he could be the President of the United States. And if he's the President of the United States and he has a corrupt son, the fact that he's announced his candidacy is a very good reason for upping the interest in his son. If he wasn't running for president, he's a has-been. He's the former Vice President of the United States. Okay, big deal. But if he's running for president, that's an enormous big deal. So the difference the House managers would make is whether the president's in his first term or his second term, whether he's running for re-election or not running for re-election. I think they would have to concede that he was not running for re-election. This would not be a corrupt motive, or it would be a mixed motive, but leaning on the side of national interest. If he is running for re-election, suddenly that turns it into an impeachable offense.
Thank you, counsel.